And then at the same time, you also have to look at one of the other reasons would be the politics of it, right? There's, you have President Biden, who is a staunch gun control advocate, who is working to tighten gun restrictions in the country, right? Whose ATF just this month reiterated that they will still charge these crimes in Minnesota, which just decriminalized marijuana. And there's many other states that do that. The ATF's position has never changed on this, that this remains illegal, that they will prosecute you, they will investigate and arrest you for it, and you could be prosecuted. Even if perhaps in practice it doesn't happen a ton, that's still the stated position. And the president's politics are that he wants more restrictions on guns, yet his son commits a federal felony, a gun crime, and instead of getting jail time, he gets a diversion program.
Well, I think people have a perception that the children families of the powerful and famous and rich get a better deal. And I don't think there's any question that they do. And I can see they're highlighting this particular issue. I think it's shameful if the ATF is going to keep prosecuting people who own a gun and use marijuana in states that have decided to make marijuana legal. I think it's terrible as a matter of federalism and all sorts of other reasons.
Obviously Congress plays a role there. The president can't necessarily, he can't change the law, although he has changed interpretations of the law to make them stricter since he's been president when it comes to gun laws. But
he could change priorities. So they've changed priorities about enforcing the still existing federal prohibition on marijuana in states where it's legal, things like that. It's a fair point that there seems to be a discrepancy.
And, I think that's been the main criticism that I've seen from like the National Shooting Sports Foundation, the Citizens Committee for the Right to Keep and Bear Arms, which is the sister group for the Second Amendment Foundation. They focused mainly on the hypocrisy of it, of like Joe Biden's position on guns and then his son getting at least what they call relatively lenient treatment when he commits a gun crime. And it kind of goes back to this idea that there's lax prosecution of current gun laws. Do you think this is a legitimate example of that, or are they politicizing it too much? What's your take on it?
Well, I think it's fine to think that there's hypocrisy or there's laxness, but I think it should be informed by an accurate picture of what really happens in the system. So a lot of people kind of assume like if there's a crime and the government finds out about it, it gets prosecuted. And that's not really the case. Again, the feds hear about all sorts of federal crimes, and they only investigate a very small number, and an even small number get prosecuted. So the laxness of gun charges and gun prosecutions under existing law is a literally guns and butter decision. It's a decision about how much money to allocate to the Department of Justice and the various agencies to investigate, charge, and prosecute those cases. They could reallocate out, and then some other areas not going to have as much money. But to the extent people are saying that this is unfair because anyone else would have gotten prosecuted and would have taken a felony for this, that's not true. As we talked about at the top of the episode, this is just so rarely charged, and it's almost always when there's some other X factor bringing it in.
Okay. And we mentioned one example of another person in a similar situation, the mother of the child the 6-year-old who shot their teacher, took the mother's gun and shot the teacher. She was charged. That certainly seems to be a case where they're using this charge in lieu of being able to charge her for something else. But let's talk about two other specific examples. Let's talk about one example that's come up sort of from pop culture that I think is probably a really bad comparison, which is so there's a rapper named Kodiak Black who was charged with this same crime and convicted and served 3 years or sentenced to 3 years in prison a little while back. And his lawyer came out and said that, this is an example of the two-tiered justice system. And because Hunter Biden didn't get prison time for with his deal. What would you say about that situation? Because Kodiak Black, my understanding is that his background is quite different.
Yeah. I mean, I think he had a impressive criminal record. And I think that the conduct there involved repeated lies in order to get a larger number of guns, and that he was prohibited
Yeah, he was a
as
felon as
a
well.
felon from having anything to do with. So I don't think they're remotely comparable. They do. I mean, if Hunter Biden were already a felon and had the gun, I think it's more likely he would get charged with a felon in possession, and then he'd be looking at real jail time. So again, I think it's a little bit of apples and oranges there.
Yeah. And but let's talk about two cases that I think are a little bit closer, at least in the sense that the people charged didn't have a long rap sheet beforehand. And also, we mentioned this at the top, but Hunter Biden, there was a story again from the Times that indicated he was going to use a Second Amendment defense if this had gone to trial. And I suppose it still could, like we talked about earlier, if he violates this diversion program in some way, maybe this will end up happening anyway. But there are two cases recently since Bruen was handed down in 2022, where federal judges have called into question the constitutionality of this exact prohibition that Hunter was charged under. And one was a federal judge in Oklahoma. It was the case for a man named Jared Michael Harrison, who was pulled over and found with marijuana and a loaded gun in his car, and he was charged for being in possession, a drug user in possession of a firearm. And his conviction was tossed by this federal judge as being not compliant with the Second Amendment under Bruen. The second example is a judge in Texas who was dealing with a case where a woman was charged for she had marijuana and a gun, but also her husband, she was charged for transferring firearms and ammunition to her husband, who was a user of multiple controlled substances, including cocaine, like what Hunter has said he used. And so both of those were tossed, both of those cases, as the judges determined that this statute can't hold up to Second Amendment scrutiny. Do you think those cases, those charges, are sort of more better analogs to what Hunter was charged with? And what do you think of the potential constitutional challenge he could have perhaps undertaken here?
Well, first of all, they are closer. They are more analogous. I don't know as much about the first one, but I think that was one where the police were looking at him and thought there were more serious things going on, but this is the only thing they could find. The second one, there was involved a larger number of guns and guns being transferred between people, which is, as you know, something the ATF is always super concerned about. So those both had some sort of X factor. And I think that the judges read, I'm not a Second Amendment lawyer, but I think the judges read of the Supreme Court's decision is a reasonable one, and one that if I had a case right now under 922, I would probably be trying to make about all sorts of subsections of that law. I think the field's wide open on these arguments right now. So Hunter Biden may actually be giving up his right to constitutionally challenge the charge in the plea agreement, which is something else we want to see. So if I were a betting man, I would say that when we see the plea agreement, it's going to say that he's agreed to waive indictment by grand jury on this information, agreed to enter a diversion program, and agreed to waive any constitutional challenge to the charge itself in the event that he violates diversion and comes back. That's an educated guess.
I didn't know that was an option. So this is why I like to have people on who know more about the subject than I do.
Stephen, any right you have, the government will ask you to waive.
Usually not a bad idea. Although I will say, my one thing I would ask on that point, because obviously as a firearms journalist, yes, it would be much more interesting to me if Hunter Biden had fought this charge on constitutional grounds and we gotten a U.S. v. Biden Supreme Court case out of it, that would be quite in the year 2024, right? That would all be quite the political story. But my guess is that if you were his attorney, you would advise him to take this deal over trying to challenge the constitutionality of this federal law. Is that?
Oh,
that
hell
right?
yes. Absolutely. Yeah. I mean, diversion, not being convicted of a felony, not having this, and, challenging the constitutionality of a law in federal court is a big enterprise, expensive, stressful, no guarantee it's going to work, and so on. So yeah, it's a very clear, easy call if you're in that situation. The only way I wouldn't do it is if I thought there was no way that he could last out the 2 years on diversion. If I had grave doubts about that, I'd probably find a different path. So that tells me that his lawyers think that he's at a place now where he can do it.
Okay. Interesting. But yeah, I mean, just as a general point, I know everybody's always cheering for constitutional challenges. And I think that the general public likes to think that, well, if you think your rights have been violated, you should take it all the way to Supreme Court. But in real life, you don't necessarily want to be that Supreme Court defendant, right?
Right.
It's not a pleasant experience.
Because first of all, he doesn't have an automatic right to go to the Court of Appeals before he gets convicted and sentenced. He could ask for some sort of emergency appeal. That's not likely to work. But if he's being prosecuted and he files a motion to dismiss on the grounds it's unconstitutional, judge says no. Now you've got to go through trial and sentencing and appeal, and you're likely in jail while you're waiting for your appeal. So that's not appealing. So, I mean, not everyone wants to be the test case. It's often not fun to be the test case.